and Guidry goes, let's go look at something that took place 40 years ago. Who cares? Okay, that's political.
Welcome. On behalf of IBM TV International Broadcast Media, this is The Lawyer's Den, a unique program dedicated to discussing legal issues that are on the cutting edge with the thought leaders in our world. So we promise this. We promise candor, laughter, but at the end of the day, you will have had the chance to be informed about the various arguments. Now, as we all know, where is my co-host and, well, not best friend, but good friend?
Yeah, your best friend is that guy who puts you down all the time, Fernando Real. Yeah, we'll have to get rid of him. But anyway, yes, welcome all to the Lawyer's Den. We have another exciting day of trauma for all those people who haven't gone through this trauma before. Now you know what lawyers do. Well, someday we'll get into that, but basically this is what they do. Now, do you want us to bring our panelist in for today, Mr.?
Yeah, if we could, Nick, that would be
okay. All right. The first person I see down on the boards actually hails from the University of Southern California. And then, after he received his bachelor's degree, he went on to the Ohio State University to receive his law degree. And then, after he received his law degree, he received an advanced degree called a Master's of Law from New York University, and currently is a professor at Georgia College. So let's give a warm welcome to Adam Lamparero. Adam, welcome to the show. Welcome back. It's like welcome back, Cotter. Now it's welcome back, Adam. But anyway, so we have the brains. Now let's bring in the beauty. This lady hails from the University of Denver School of Law. Then she also has a Master's of Law, originally from Lithuania, but now practices law in Florida, a true international person, the person with class. Let's bring in Guidry Stansley. Guidry, welcome to the show. And by the way, she's also an artist. She painted everything behind her. At least I found that out not too long ago. Okay, so now that we have class and we have brains, we're going to someone who lacks class. I mean, either. I shouldn't say that. But he's a street fighter from the State University of New York in Buffalo. And now he's a street fighter in New York City, the big banana. Oops, Big Apple. Let's bring in our street fighter, Fernando Real. Fernando, welcome to the show.
Hey, Nick.
We always have to get that New Yorker in there, you know, so we have a real New Yorker to the panel, you know. Yeah, it's all in New York.
You're either going to love us or hate us. That's why it works out.
No, it isn't. It's just everybody knows if those are the two choices, what we're going to choose. But this person isn't in New York. He's in a different city, not New York City. How about Salt Lake City? From the West, he received his bachelor's degree from BYU and also master's at George Washington. Let's bring in our person licensed before the United States Supreme Court, Jeff Teichert. Jeff, welcome back to the show.
Thanks for having me once again.
Yes, and of course we have our den master, who is also an attorney, licensed in many jurisdictions, the Honorable William Trezevant, the den master. Okay, den master, what's the topic for today? What are we going to be discussing, fighting over, or whatever?
No. We're going to have an engaging discussion tonight. I'm hopeful, and I think it's going to be quite interesting. But we have our thoughts, and that is simply this: that it's always been a discussion that people have thought about and have been arguing now for almost 40 years, if not longer, and that is Roe v. Wade. Now, for our purposes here in the Lawyer's Den, I will call this Roe versus Wade 2. Because back on January 19th, the Lawyer's Den took up this subject, but if everybody will recall, that was before the change in the Supreme Court. And at that time, for whatever reason, Adam left the den. I don't know if he was losing the fight or whatever it was, but halfway through, he took his marbles and went home. Now, at the time, he blamed it on technical issues. Tonight, I am assured by him that he is not leaving this argument this time. And now, Nick, with your indulgence, I want to begin with you. Just a simple question, just for our audience purposes. You are going to be putting the Lawyer's Den Roe v. Wade 1 up on IBM TV, so that our audience will be able to see the before when Adam ran away, and the after when he decided to stay. Nick, you be doing that?
Yes, yeah, they'll be able to see both of them on the IBM TV network. That is correct.
Fantastic. Now, with that, okay, well, with that, for a brief introduction, I'd like to go to Guidry. Guidry, may I ask you, I mean, I think we all know Roe v. Wade, but were there any developments that you may know of that we may need to update our audience on? Guidry?
Thank you, Bill. As the only panelist with uterus, I will take the microphone from you to talk about, just to mention 3 main cases. So I think it is very important before diving into Roe v. Wade to know what happened in the legal spectrum of abortion jurisprudence. So in 2020, the Supreme Court struck down the Louisiana law, which essentially required doctors performing abortion to have admitting privileges in nearby hospitals. And the reason for striking that law down was that it provided the undue burden for women, for their health, for each of the abortion, and it was substantially similar to the law, to the identical law that was struck down in 2016, and that was the only reason why the conservative Justice Roberts joined the liberal wing. So that happened in 2020. Now, when we go to 2021, we have a new justice join the panel, Justice Beret. And there was a first decision regarding to the abortion that she took part 2. And that decision involved a Food and Drugs Administration, and particularly the requirement imposed by them for women seeking abortion via pills to go in person to pick up those pills, either in clinic or in hospital, after being diagnosed, after being prescribed those pills virtually. And the reason, and here the Supreme Court dodged the bullet, if I may to say so, by deciding not to dive into the merits, but instead they said that federal judge did not second question the such esteemed political institution as FDI, and therefore the federal judge should not have put into his decision the consideration that he knew better what is healthier, what is safer for women during the pandemic. So that was the decision. And I really, really love the dissenting opinion by Justice Sotomayor. I love her in general, but she primarily stated that the justices in this particular case almost like cherry-pick the statistical data provided by the Trump administration, and they made this decision based on reading the tea leaves. And it's really brilliant dissent. The main decision written by the justices is not worth of reading. However, the dissenting opinion is great. And finally, we are coming to the current week of 2021. And right now there is buzz that on Monday, Supreme Court agreed to hear a case that is based on Trump's administration's attempt to limit certain federal program that is also known as Title 10, and that program imposes certain limitations on the on the rights of the poorer community to procrastinate, meaning that that particular title says that the Trump's administration, they want to prevent hospitals and clinics to use the resources provided by this title if they refer the clients for the abortion to any other clinic. So we will see if we will hear the decision on that. It is possible that we may not, because there is also some indication that current Biden's administration is taking the stand that that they might give something more tangible against this attempt of Trump administration to curtail the right to the abortion. Long and short, done.
Okay, well, there's been a lot. And I think, listen, I mean, we didn't even have to wait a year for all that, let alone since 1973. Now, Jeff, I'd like to come to you. Jeff, can you share your thoughts since our last Roe v. 1 here in the Lawyer's Den, please? Jeff?
Sorry, I had to unmute. With regard to what Guidry just said about the decision that the Supreme Court may be taking up, the Biden administration can reverse that HHS policy merely with the stroke of a pen. It was imposed with the stroke of a pen. Why would the Biden administration choose not to? The only way they wouldn't is if it looked to them like they could get a Supreme Court precedent and have the Supreme Court do what they're able to do themselves. I think perhaps if they maintain the case, it's moot. But be that as it may, I don't think it has anything to do with Roe versus Wade. I myself might find myself voting, if I were on the court, might find myself ruling that the regulations are simply illegal under the statute. And that has nothing to do with any constitutional right to abortion. With regard to Roe versus Wade, which I assume is the underlying subject of today's discussion, I would like, as Guidry did, to quote a dissenting opinion with which I agree. Justice Scalia said in the Casey decision, the states may, if they wish, permit abortion on demand, but the Constitution does not require them to do so. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. As the court acknowledges, where reasonable people disagree, the government can adopt one position or the other. The court is correct, adding the qualification that this assumes a state of affairs in which the choice does not intrude upon a protected liberty. And of course, Justice Scalia believes that it does not. He says a state's choice between two positions on which reasonable people can disagree is constitutional, even when, as is often the case, it intrudes upon a liberty in the absolute sense. Laws against bigamy, for example, which entire societies of reasonable people disagree with, intrude upon men and women's liberty to marry and live with one another. But bigamy happens not to be a liberty specially protected by the Constitution. Then that is quite simply the issue in this case, not whether the power of a woman to abort her unborn child is a liberty in the absolute sense, or even whether it is a liberty of great importance to many women. Of course, it is both. The issue is whether it is a liberty protected by the Constitution of the United States. I am sure it is not. I reach that conclusion not because of anything so exalted as my views concerning the concept of existence, of meaning, of the universe, and of the mystery of human life. Rather, I reach it for the same reason I reach the conclusion that bigamy is not constitutionally protected. Because the Constitution says absolutely nothing about it.
Okay, well, thank you, Jeff, because you just, come on, seriously. And reading into an entire dissent, which is not even the controlling authority, is just not
two paragraphs.
Adam, please, Adam. Unmute Adam first.
Okay, outside of Plessy versus Ferguson and Korematsu versus United States, Roe versus Wade was the single worst decision of the 20th century. And it was the single worst decision for one reason. The Supreme Court distorted, in fact, manipulated the text of the 14th Amendment to the U.S. Constitution, which provides procedural protections for people who are threatened with the death penalty, life imprisonment, or property forfeiture. It ensures fair procedures for these individuals. The Supreme Court manipulated the Constitution, namely the 14th Amendment, to create an unenumerated right to privacy that it first created in Griswold versus Connecticut and later confirmed in Planned Parenthood versus Casey. So what the court did was it made up law. It rewrote the text. It disregarded the text. Now, I'm pro-choice. I am firmly pro-choice. But the way that the Supreme Court reaches decisions should matter, because when the Constitution says nothing about an issue, it's left to the democratic process, to the people. As Guidry said last night, we the people. So when the Supreme Court took it upon itself to decide an issue that people in all 50 states had a right to decide for themselves, it was fundamentally undemocratic, it was unjustified, and it was completely illegitimate. Roe versus Wade was a terrible decision because the Supreme Court got to its outcome based on its subjective values and used illegitimate means to do so. In a democracy, that should never be tolerated. That's antithetical to liberty.
Okay, great. Fernando, your opening thoughts, please. Fernando.
Sorry about that. Usually I'm pretty good at unmuting. Yeah, I disagree with Adam. Disagree with the dissent by Scalia. I do agree with Guidry that Sotomayor's dissent is the right portion of that decision that should be read involving the FDA, because let's face it, the court just punted. They found a way to hide and not make a decision because, in all honesty, courts interfere with government bodies all the time. And they override what they have to say, and they override experts all the time. So at this juncture, it shouldn't have been any different. I don't agree that this should be an issue that should be left up to each state, for the simple reason that you have 50 states who have 50 different ways of viewing this. And those states that legalize abortion will have people flooding into their states to get abortions. If we make abortion illegal throughout the country, we're just going back to the way it used to be, where the rich would fly to Europe, get an abortion, hang out in Europe, make believe that they were studying abroad, and then come back. The people that get screwed are the poor women at the bottom end of society, where they're using coat hangers and going to a pharmacy to get injected with God knows what. And we're creating another public health issue. As for the Title 10, I don't think the Biden administration is going to wait for the court to make a decision. My hunch is that they don't want to roll the dice, that they'll just get rid of it through executive order the same way Trump instituted it by executive order. Better to be safe than sorry.
Okay, and Nick, your opening thoughts, please.
Yeah, I think it's about time we get to listen to somebody who has some reason on this panel. Listening to Adam talk about Korematsu being a bad case, one of the worst cases, Roe versus Wade, with no context. I mean, typical lawyer. He'll throw out a case but not give context to what Korematsu was all about. And so the thing is, we were just sitting there guessing. A lot of lawyers do that. Then they'll throw a Latin phrase in and no one knows what they're talking about. And Korematsu was not poorly decided. It was decided a long time ago. This is during World War II. People were scared to death, and they basically moved people with Japanese ancestry inland because they were scared to death they're going to be invaded. But Adam, sitting on his high perch in Georgia, goes, "Oh, it's a bad decision." Roe versus Wade, a bad decision. Well, the worst decision? Probably not. Is it a bad decision? Well, here's what really happened in Roe versus Wade. They cut the baby in half, literally. Okay. In other words, what they did is they said, well, if you make it past, the first trimester, you're now considered a human being. If you're not, then you're not considered a human being. So they literally cut the baby in half, allowing us to cut all the babies in half that didn't make it that far. And that's what Roe versus Wade is all about. And Guidry will jump up and so Fernando, women's right to choose. Right to choose. Yeah, they had a right to choose. They had a right to choose once they had sex. I mean, come on. That was the time they actually made the choice. Once they made that choice, you basically abandon this, quote, fictitious right to choose. So yes, Roe versus Wade is a bad decision because they literally cut the baby in half, and hopefully we'll have a good discussion about baby being cut in half on this panel.
Okay, well then, look, and I want to ask this question because I really just to get back to the basics on this, and that is, the argument seems to be convoluted at this point, at least based on the opening remarks. Number one, Roe versus Wade was decided on the presence or absence of privacy in the Constitution. And the question becomes, did that privacy exist prior to Roe v. Wade, or was it made up whole cloth? Because if it existed prior to, and Roe v. Wade was based on prior Supreme Court decisions, then you can't come now and say that somehow Roe v. Wade is bad. Because if you're doing that, then maybe you're exercising your own opinions and whatever it is. But the question is, was it constitutionally decided? Now, here is the rub. In this second conversation with Roe v. Wade, too, here on the Lawyer's Den, and I really want to drill down to this. I want to understand whether or not, from each of the panelists, do they think Roe v. Wade was decided wrongly because there is no right to privacy in the Constitution, or that they think Roe v. Wade was decided based on a wrong provision in the Constitution. And that's a very important distinction. And for this, I'm going to go to Adam, because Adam, this is a direct question to you. Because I know that in the wait, before you go, because I want to make it crystal clear before you go in talking about people decide and how you're represented and all the other gobbledygook that you always throw out there and how you're going to be mischaracterized. I want to be clear that in the prior discussion, you said that Roe v. Wade, in your eyes, was decided wrongly because it was based on the wrong amendment. Not that you disagreed with the conclusion, you just disagreed with the way they got to their conclusion. Is that right, Adam?
That's partially correct. Roe versus Wade is based on a theory called substantive due process that makes no sense. The 14th Amendment to the U.S. Constitution protects procedural rights, the right to a fair trial, a fair hearing. It does not protect substantive rights. In Griswold versus Connecticut, the Supreme Court invented a right to privacy out of penumbras that they claimed, invisible penumbras that they claimed existed in the Constitution, that gave the Supreme Court, and only the Supreme Court, the right to create rights that the Constitution never, ever mentions. And that is antithetical to democracy, because our entire democracy is based on giving people the right to make decisions about what rights they're governed by when the Constitution is silent. And let me just say this. Lawrence Tribe, professor at Harvard, severely criticized Roe versus Wade, saying that there was no constitutional basis for the decision. Ruth Bader Ginsburg, one of Guidry's heroes, also criticized Roe versus Wade, saying there was no substantive basis for the decision. John Hart Ely called the doctrine that the Supreme Court invented to recognize this unenumerated right green pastel redness. It was undemocratic. It was 9 unelected justices taking power onto themselves to make law for 50 states and over 300 million people. That's undemocratic, and that's wrong. People get to decide when the Constitution is silent.
Okay, well, that's fine, Adam. But you see, that doesn't answer the second part of the question, that I think that you implicitly admitted that I was partially correct in the characterization of your previous position.
Okay.
No, Adam. I want to be clear now, because I heard why I was wrong. I want to hear why I'm right. And then, Guidry, I'm coming to you. But why I'm right is that you would find the right that would support the right to abortion in the Constitution based on a different amendment. I have that correct, don't I, Adam?
I would base it on the Equal Protection Clause because of the horrible burden that abortion restrictions place upon women. Yes, but that wasn't what the Supreme Court did. What it did was it created a doctrine that allows the court to create whatever rights it wants and usurp the democratic process.
Okay, well, fine, Guidry. I mean, isn't Adam just saying that, the directions that we got on Google Map is different than the directions we got on, Amazon, from Alexa on Amazon, and that he would prefer the directions we get on Amazon to find the right rather than Google? Isn't that what he's essentially saying legally?
Well, Adam is professor. He has to say that. He has to go to that direction. But yeah, you're right. I think he's definitely that's what he's saying. And the interesting thing is that Adam is saying, well, when the Constitution is silent, people have the right to decide for themselves. And in this particular case, Roe v. Wade decided that people have a right to decide the matter in regards to abortion, which goes to privacy, or according to Adam, should go to Equal Protection Clause. And I know Adam meant by that voting, the process of the population as a response to legislatory concept of our institutions. However, we have to still take in consideration that at that point, states had placed a lot of roadblocks when it comes to women's reproductive rights. And Roe v. Wade was decided in 1973. That's really, really late date. And at this point, the Supreme Court responded to the sentiment of the nation, and something had to be done, and had to be done unilaterally that could affect every single person's right to make a decision when it comes to their reproductive rights. And another thing I want to mention really quickly, right to abortion is not an absolute right. So there are also constraints attached to that. It's well regulated, as it was mentioned before. And it also has to be taken in consideration when we're having this discourse, this discussion about the abortion.
Okay, well, Jeff, no, hang on, Adam. Jeff, if I may, I guess the question is this, that you say that, well, Guidry makes the point that Roe v. Wade came along, the decision, came along because the courts had to act given what was going on in the nation and the society, and that they were essentially late to the party. And I think some arguments have been made that because it was based on privacy rights that the Supreme Court had found prior to, beginning way back in 1910, then 1912, and then all these other things, that they merely expanded the right to privacy. That's how the Supreme Court got to it. So the question, I guess, for you, Jeff, is this. Do you think it's unfair for the Supreme Court, although they're late to the party, to confirm rights that they had been already confirming, and that it's so horrific that the people didn't vote first, Jeff? Or are you just saying, as an originalist, that the Supreme Court can't act at all to change with society the Constitution? Jeff, you. Jeff, you have to unmute.
Sorry about that. Let me make one point before I directly answer that to make sure that our audience fully understands, because this is a common misconception. A lot of people believe that if the Supreme Court was to overrule Roe versus Wade, that would suddenly make all abortion in the United States illegal. It would not. What it would do is it would remove the pronouncement of the Supreme Court that there is a constitutional right to it. So what it would do is put the regulation of abortion back in the hands of state governments, and they would have much more latitude on which to regulate. So that's the first thing. Secondly, with regard to the question, yes, my opinion as an originalist is not that abortion is an unimportant issue, or that there wasn't a lot going on in 1973 that prompted the Supreme Court to act. My contention is that the Constitution says nothing about it. And furthermore, we see every time there's an abortion case in front of the Supreme Court, we see people picketing outside and demonstrating and a huge public outcry, as though they could say, we're going to somehow vote Justice Roberts out in the next election if he makes the decision that we don't want. Guess what? The guy's life tenured. They all are. So all of this picketing and stuff is really of no effect. And if you want to be able to have your voice heard, put it back into the political system, because then, win or lose, at least you'll feel, and everybody involved will feel, that they had the benefit of a fair fight. And maybe we'll get some reasonableness back in the debate, where we can talk about, all right, what are the reasonable restrictions on abortion that can be brought to bear, and what reasonable freedom do people need to have to be able to make decisions with regard to their reproductive lives. And we'll treat it like we treat everything else in a democracy, and try to create some kind of a balance. And Fernando talked about doing, how it would be bad to do it on a state-by-state basis, and that's bad policy. What I'm going to say about that is that's a lot of wishful thinking. It's saying, well, I think it would be better if we had a uniform standard throughout the country, therefore the Constitution mandates that. It does not. The Constitution says absolutely nothing about abortion. It implies absolutely nothing about abortion. So
No, Jeff, that's fine. But you see, that's an originalist argument. But the Constitution does imply a right to privacy, and it has so for over 110 years through various cases, all leading up to Roe v. Wade. But I want to leave that aside for now, but because I want to go to Fernando. Fernando, Jeff's position is throw it all to the vagaries of state elections. How are you thinking about that, Fernando?
I love Jeff, but his position is complete and utter nonsense. This thought that if you throw it back to the states, everyone is going to come up with the right solution, all this other stuff, is nonsense. And it is ignoring the history that existed prior to Roe v. Wade. Whether Jeff and Adam and everybody else likes it or not, we have a federal system, not a confederacy of states. We have a federal system, and it was specifically designed by our founding fathers to be a federal system where the federal government sets the floor and the states follow, whether they like it or not. Yes, there is a clause that says if something has been left unsaid, then it's up to the states. Guess what? Those instances are few and far between. the Supreme Court, to answer another issue here, has made plenty of decisions where it has not been found in the Constitution. It wasn't enumerated. It wasn't stated. Guess what? A national bank is nowhere to be found in the Constitution. Our founding father, Hamilton and Jefferson, both agreed. Somehow they came up with the necessary and proper clause and said, hey, we wrote this. It applies here, so we're going to use it. Guess what? That's what courts are supposed to do. You think, you look, you apply, whether you like it or not. Adam, you can shake your head all you want. Jeff, you can shake your head all you want. Two, the fact is that the right to privacy existed prior to Roe v. Wade. Roe v. Wade wasn't the first case to say there is a right to privacy, and you know that as a professor, Adam. If you don't, people should start dropping your class. Also, the rights to substantive due process and procedural due process existed prior to Roe v. Wade, and they were stated to be found in the 14th Amendment. And the 14th Amendment, the last line says, nor deny to any person within its jurisdictions the equal protection of the laws. That to me says that the court did use the proper clause. I'll agree with you also. Equal protection is also another great clause that they could have used, but they didn't. So what? In either event, they got it right, whether you originalists like it or not. And if we're going to live to the four corners of the Constitution, then hey, we should bring back 3/4 of a person, and that, you know, slaves should exist, because that's what it says in the original document. Whether you guys like it or not, it's in the original document. So hey, let's go back to it. As to Nick's point, they aren't even worthy of addressing, because they're just rich man nonsense. Because he'll be able to send his kids to Europe to get an abortion and keep it quiet, like every person who's anti-abortion on a national platform has done, and then it comes out in the papers. Whether it's that senator, was it in Pennsylvania or somewhere, and then the other senator in down in Alabama. And by the way, throwing it back to the states, the other problem with that is that you have a Christian Taliban in this country that wants to come hell or high water to strip a woman her right to make a decision based on her economic and emotional circumstances at the time of her pregnancy, period. Therefore, those people need to be kept in check. And what we should have at this point is just a federal statute that makes it legal, and this ends this entire argument.
Okay, Nick, I'm coming to you, and Deidre, I'm coming to you. All right, Nick, please first.
Unmute.
I did the same thing. Okay, if Fernando is ever able to read the Constitution of the United States, if Fernando ever read the Declaration of Independence, it says specifically that the state shall not deny any person life, liberty, or property without due process of law. And here, what we're saying, when you're upholding this cut the baby in half rule, or even worse, let's cut the baby in half anytime we want to rule, what we're doing is we're depriving a person of life without due process of law. I would ask this panel, this is what we really need to do. If you think this is such a great idea, let's ask some of the survivors, the people that the abortion didn't go right for them and they actually lived, what they think about cutting the baby in half. No, we don't do that. Let's have them have an ability to have due process of law. And yes, of course, Fernando's totally against the Christian right, because in this case, they're actually right, because they're pro-life. Fernando would say, well, if your kid's a little bit deformed, kill him. Why not? Concentration camps would be good, because we just don't like how that person came out. That's fine. That's a degradation of life. And this is just another example of it. And that's the reason the right is right in this particular issue, not the left.
Deidre,
Bill, can I just say one thing?
Sure.
Nick's argument is wrong. Nick's argument is wrong for the same reason Roe versus Wade is wrong. It resorts to the due process clause for substantive content for things that aren't really.
Okay, Deidre, please.
Wow, Nick, that was something for sure. I agree with Fernando wholeheartedly. I do think that state is very divided right now, throwing a ball to 50 different states to figure out the most contentious topic, issue that has been lingering here around us like a white elephant, day-to-day basis. Really, every single person has been touched or talked about it or read about it and has an opinion, very heated opinion about it, throwing that back to our political atmosphere would be, I think, would be very detrimental. In addition to very solid arguments that Fernando said, I do not think that states are capable to resolving this issue. I do think that there would be a lot of roadblocks done, and we don't need to look far behind. We actually need to look at the very recent case that we just mentioned before, the FDA case, that the justices decided to skip. And the interesting fact that could show this sentiment of the people when it comes to the abortion is that, think about it, during the FDI case, we were in the midst of the pandemic. At the same time, at that time when this case was being decided, there was an issued different health announcements that people were encouraged to incorporate the telemedical appointments, assessments, medical prescription. So a lot of different medical procedures that required even prescription of opioids were actually okay by person being evaluated virtually. However, oh no, the abortion pill that is really being used within 10 first week of pregnancy was okay to be diagnosed, to be prescribed virtually. However, the person was punished, forced into the middle of the pandemic to go in person to pick up that pill. So the sentiment really shows that our nation is incapable to really dive into this matter unilaterally, put aside their heated sentiments, as Nick mentioned, the baby cut in half, where my opinion is that there is no baby, there is fetus, and we could discuss on when fetus becomes alive and when that life gets protected by the Constitution, as Nick cited. However, putting it aside, my point is that we should not break something that is functioning. We should go with it, and we should try to amend it, to resolve it, and to discuss it.
Adam, you have the floor. Unmute, Adam, please.
Excuse me. Obviously, Fernando has had a very bad day, so I'm going to excuse his silly outburst. Guidry is motivated solely by ideology and would turn our country into Russia, Iran, or Pakistan if she had the chance. The fact is this. Yes, Fernando, I know there was a right to privacy in the Constitution that was not in the Constitution, but that the Supreme Court invented before Roe versus Wade, which was highlighted in Griswold versus Connecticut. They are making up law. They are disregarding the Constitution. They are creating doctrines that give 9 unelected and life tenure judges the power to make decisions that are reserved to the democratic process. And when you do that, okay, you get decisions like Citizens United versus FEC. You get decisions like McCutcheon versus FEC. You get decisions like Shelby County versus Holder, with which I'm sure Guidry, subsumed in her ideology, would agree with. Now, the role of a country in a democratic society is to limit the power of the federal government and give people the power to make decisions regarding the rights under which they're governed when the Constitution says nothing about it. The Constitution says nothing about abortion. Zero. The justices had to invent law. They had to invent rights. And that's wrong in a democracy. And I don't want to live in Russia. I don't want to live in Iran. I don't want to live in Pakistan. I want to live in a place where we, the people, mean something.
All right. Okay. That's great. I just have a couple of quick questions for you, Adam, if you don't mind. May I please? When you start talking about, the voting rights and everything else, we've already seen what the results of those voting rights were. And that's why it took the court in 1973 to upend all the oppression for 50% of the American population. And so my question is that it's been raised by this panel. For all those advocating, let's throw it back to the states. Fernando raised a very important point that different states are going to decide different ways based on whatever's going on in their states. Now, is that fair to 50% of the population to tell them that because they live in one particular state, they get more rights versus in another particular state, they get less rights over their own body? No. Is that fair to deny 50% of the American population their rights just because of their gender, Adam?
It is 1,000% fair, and you're mischaracterizing it.
No,
every citizen in every state has a vote.
No,
I don't see Guidry outside of the Florida state legislature advocating for change. I see her saying, let's let 9 unelected judges impose their law on an entire nation.
No, Adam, that is unfair, because what you're doing is you're placing these unrealistic requirements on Guidry's actions when, because of her right as an American citizen, her rights should just be there. She doesn't have to go and fight.
I'm saying that the legislature is the place for change, and it's called a democracy. And if Guidry can't handle a democracy, well, then I don't know what to tell you.
Fernando, I want to go to you, please, because I want to ask you, because Adam has clearly just said, hey, listen, Guidry's got to go out and pound the pavement every day in order to have her rights as a citizen, because if she doesn't and she snoozes, she loses. Now, Adam, I'm going to ask you, and I know this is a bit off racial topic for you, but I'm going to come to you, and then Jeff, I'm coming to you about Adam's spurious argument about having to pound the pavement every day just to be an American citizen. Fernando, you mentioned earlier that under these arguments, African Americans would have to go back and pound the pavement every day just to fight every day the 3/5 Declaration and the United States Constitution that the originalists seem to believe. Now, Fernando, do you think that's a fair standard? And if you don't think that's a fair standard, do you think it's then a fair standard to apply to 50% of the American population to tell them that they have to do the same thing? Or do we just have rights because we're American citizens? Fernando first, and Jeff, I'm coming to you.
No, we have rights because we're American citizens. And this whole concept that we're a democracy and send it back to democracy. You guys keep forgetting we are a republic based on a federal system, not a democracy based on a loose confederacy. We tried that during the revolution and we almost lost because the 13 states couldn't get together to figure out how to pay for an army, raise it, and fight a war. I would suggest to Adam he should read the Federalist Papers so that he can learn how our system is supposed to work. Madison, Hamilton, Jefferson, John Jay laid out a great groundwork. The same for Nick, because I have read the Declaration of Independence. Yeah, I know I'm only from New York, and I wasn't here since the 1600s, and I wasn't here when it was written, but I've read it, and I've read the Constitution. And the protection of life, liberty, and property, guess what? The life that we are protecting is the life of the mother, the one who is alive, who is walking, who is breathing, who has to carry a symbiotic human being inside her, who cannot stand on its own 2 feet. So therefore, no, it is not a life as of yet until it can come out and actually breathe and sustain itself on its own. It is the mother's life that has to be protected, whether Nick and the rest of the Christian Taliban likes it or not. Because the funny part is, after this child is born, then all of a sudden it becomes, hey, you're going on welfare? You're getting food stamps? You're getting WIC? What the hell is wrong with you? How dare you? So really, it's not that you're pro-life. What you guys are pro-birth. And then once the kid is born, then now we kick it to the other side and start complaining that you're sucking up a lot of resources. And again, this concept that it's not found in the Constitution is just nonsense. Not everything is written in the Constitution. That's why you have to read it and apply. If you're going to go based on that concept, then yes, you're going to have to go back and take a woman's right away from vote to vote. You're going to have to go back and make people slaves again. You're going to have to make them 3/5 of a person. And they're going to have to sit there and go pound the pavement, which is completely wrong because they have a right. They have rights. They have rights to due process. They have a right to, yes, life, liberty, and the pursuit of happiness, and life, liberty, and the pursuit of the protection of property. And to sit there just to the four corners does not move our country ahead. The reason that we have been able to move ahead is because we have had intelligent jurists such as Holmes or Cardoza or Leonard Hand, who have sat there and looked at the law and said, hey, it says this, but when we frame it with society, this really is what we're trying to do. And you push society forward. Okay. And you give people a right to vote and everything else.
Okay. Jeff, your thought. Unmute Jeff first, please. And then, because I want to hear all of your arguments.
All right. Boy, I don't know how to fix all the nonsense I'm hearing tonight. First of all, let's talk about privacy because nobody's gotten directly to the heart of the matter. I disagree with Adam. I think there is a right of privacy in the Constitution, but the right of privacy is that you are able to be secure. You have a right to be secure in your person, papers, and effects, and free from unreasonable searches and seizures, and that warrants issue upon probable cause. That gives you a zone of privacy in your personal effects, your home, your body, where the government can't just come in and start looking for evidence that you've committed a crime or whatever without probable cause. Now, that doesn't mean that I can do literally anything in my home that I want. It doesn't mean that I can beat my wife just because there's a zone of privacy around my home. Maybe I can get away with it more easily, but it doesn't mean I have the right to do it. By the same token, a privacy right doesn't mean that a person has a right to kill the unborn child within them just because they're protected in having a zone of privacy around their home, their doctor's office, their body, whatever. So let's dispense with that argument. It's ridiculous. Now, with what Fernando just said, the 3/5 of a person argument. Okay, we eliminated that by constitutional amendment. We didn't have a continuing constitutional convention of 9 gray-haired old men that have never been elected to anything decide by judicial fiat that something brand spanking new was going in the Constitution. Now, I'm going to give you a little, the first character in a parade of horribles. Nick talked about the Christian Taliban, as Fernando calls them, finding that really the Constitution says that abortion is impermissible because we have the right to be protected in our lives and not to have our lives taken without due process of law. Could the Supreme Court come to that conclusion? Well, if they can come to the conclusion they came to in Roe versus Wade, they damn well can do what Nick just suggested, because it's the same reasoning. The difference is the Supreme Court said, we think that abortion is a protected liberty within the liberty clause of the due process clause, and that you can't take that away. And somehow this freewheeling liberty analysis allows us to make up anything we want and say that is a constitutionally protected right. Now, I don't agree with what Nick said, and I don't agree with what Fernando said, but I know this: the due process clause doesn't have anything to do with abortion. The Bill of Rights was created by James Madison and the other founding fathers because those are the things that a dictator would try to take away if he was taking power and centralizing power in himself. He'd take away trial by jury. He'd take away the due process clause and become judge, jury, and executioner. He'd take away the right to bear arms the way we talked about yesterday. He'd take away free speech. I think the last thing on his mind would be to go raiding abortion clinics. It's just not part of centralizing power in a dictator. It has nothing to do with the Constitution, nothing to do with the Bill of Rights.
Okay, no, Jeff, I appreciate that. Nick, I'm coming to you, but I'm coming to you with a twist. Because I think what Jeff fails to mention is that amongst the rights that an authoritarian or a dictator would take away, amongst the various things that he cited, would also be a right to privacy. That is to say that they would be able to go in to your home and tell you what to do, when to do it, and how you do it. And that's what they call North Korea. Now, with that slight change, Nick, what are your thoughts given this? Because I happen to think an authoritarian dictatorship would go in and start telling you what you can and can't think, what you can and cannot do, and that's your right to privacy. And Jeff, I hope you find that as a friendly amendment. But I think we have it in the Bill of Rights. But Nick, you got to unmute first, please.
Counselor, I don't believe we need to look at this right to privacy. The right to privacy is only if you defend that obnoxious thing which is killing unborn children. Now, Fernando goes, well, they're not alive, so we don't care, which is obviously wrong. Fernando, if they're not alive, then why do you need to have a doctor come in and kill the thing that's not alive? Why do you need a pill to kill something that's not alive? Of course there's life there. And that's what this is all about. If you read the 14th Amendment, the right to life, that's what it says. But what we do is we like to do convenient labels. One label is, oh, it's an abortion, like it's something different than killing. Let's call it what it is. We're killing something that's alive. And then we go on further. Guidry goes, it's a fetus. Let's just go ahead and kill it. And that type of reasoning got us into a trouble for years. Oh, it's a black person. They're different. They're Jewish, they're different, whatever, they're different. And you label them and they say, hey, it's okay to treat them different because we just put a different label on them. It's not okay. Okay, they're alive. And that's the reason why Fernando is totally off base, because if they're not alive, then there's no reason to have a doctor. There's no reason to take the pill because they're not alive anyway, so who cares? But unfortunately, Fernando, you're totally wrong. Once again, they are alive, and that's the reason we have to create this fiction called abortion rather than killing, which is what it really is. And then we say we can't find it in the Constitution, when it sits right there, the right to life. And forget trying to protect all these whatever these wingers are with right to privacy and women's right to choose and all that other garbage. All that choice was made between those two parties once they had sex. And then to equate this with bigamy, give me a break. Bigamy is a lot easier than this.
Adam, we're coming to you, and then Guidry, I'm going to need your reaction to everything that you've been listening to. But Adam, I'm coming to you first. Unmute first, please, Adam.
Well, I of course I agree with Jeff. Yes, there's a privacy right in the Constitution. Of course, it's in the 14th. It's in the 4th Amendment, not the 14th Amendment. What Guidry is discussing is purely based on policy. She is engaging in a policy analysis. Policy decisions are reserved for the legislature. Judges are required, when interpreting the Constitution or statute, to give reasonable meaning to the words, okay, and not invent meanings that aren't reasonable, invent rights that a statute or the constitutional provision at issue never provided for. The reason is because we want to limit judicial power, because we want to make sure that power is reserved to the people through the democratic and political process and through their elected representatives. What Guidry wants to do is centralize power. She wants to turn us into a different country, a country where law is made from the top down, not the bottom up, where power is centralized, not decentralized, where citizens don't have liberty, rather we have an oligarchy. And make no mistake, all of her discussion is predicated on policy, because if she likes the outcome, then it's a good decision and process doesn't matter. I reject that. I believe in freedom. I believe in the people. I believe in liberty. I believe in democracy. And I believe in equality. And the Supreme Court in Washington versus Glucksberg was clear in 1997. Issues that are not mentioned in the Constitution are reserved to the democratic process. Rehnquist is right, Guidry is wrong, and Fernando is...
No, Adam, please. We won't know her position until we hear her position. So let her just let her advocate her position. Guidry, you have the floor.
Thank you. Well, one thing is clear from this blood that I heard that Adam is a believer. Good for you, Adam. But you know what happens when the politics fail the people? The abortion has been over politicized. The Supreme Court has to make a decision, and the Supreme Court has to interpret the environment of the society, which happened in this case. And I'm standing behind what I said before. I think the numbers talk. I think Adam is somewhere there teaching, comfortable, cozy, reading some books, some decisions, thinking about, right to privacy or equal protection. When it comes to being a woman, when it comes to growing to be a woman, going through different stages and going, of your life, meeting different people, interacting, hearing a lot of different stories, I can say that women's rights have to be protected. And there are more obstacles than, are mentioned by this panel here. And it's not that simple, Nick. It's not white and black. You do not have an all decision. You do not have a picture of your life when you have sex first or second time when you're 18, 19, 20, whatever, what point at your life you are. Things happen, and things happen to a lot of people. And you know why? We need to look into the number of how many abortions are being performed approximately in the United States. And we are going to be around, based on CDC, 1 million. And there are also some numbers that are not reflected, meaning that abortion is going to be part of our society. So now the question is, as Fernando mentioned, are we going to criminalize it, penalize it, put it somewhere in a dark corner and leave women with a few options, especially poor women? Or we're going to open our eyes, put up our big boys' pants, and we're going to deal with it, facing it that, yeah, maybe it's unpleasant to me. Maybe my beliefs are a little bit different than yours. However, I'm willing to listen, and I'm willing to at least attempt to understand what it means to be a woman, a young woman, a woman who is growing and learning, and to have some options or at least solutions when a disaster, for the lack of better word, happens.
Okay.
Can I say something, Bill?
No, because we're going to go around the panel here. I want to ask this question because we are, looking at some time, but this is an important question, I think. Now that we've gone through and fleshed out the various positions and ideas and notions and arguments and discussions behind Roe versus Wade, whether you agree with them or you don't, Roe versus Wade and its progeny is in fact the law of the land. I think what we're facing now is whether or not there can be restrictions placed on the right to an abortion and protective health services for women, whether we can place restrictions, so many restrictions, that it actually obliviates and vitiates the very right that is conferred to them. Because I think we're in that stage now where, because people are making this argument now that each and every single one of these incremental cases that have been raised, whether it's the right to have the abortion pill or all these other things, become these, quote, on the one side, reasonable restrictions. On the other side, they become unreasonable to such extent as that they abolish the very right. What I'd like to hear now is, I want to ask this panel, and I'm going to start with you, Nick, and then I'm going to come to you, Jeff, and go along the bottom. And Deidre, I'm going to end up with you. Do you think the challenge now is, as we look at Roe versus Wade and its progeny, a question between regulating it so much, they're very right, so much so that the right no longer exists? Or do you think that that these are actual reasonable restrictions? But I think you, Nick, would just get rid of the right altogether. But Nick, I want to start.
Absolutely. You just get rid of it altogether. And what Fernando says, well, then they have to go to Europe. Too bloody bad. The United States was predicated on principles, my friend. And one of those principles was the right to life, liberty, and the pursuit of happiness. We're going to abide by those principles. And if you don't like it, yeah, go to Europe or go to Mexico or bloody go somewhere else. Now, Guidry's argument, well, 3 million people, we got to count the numbers. Come on, Bill. If we're doing that, we'd say we need to bring back slavery. Why do we have to bring them back? Well, 3 million people are enslaved. We can't get rid of, make them non-slaves again. That would be totally wrong. Unfortunately, we're a principled nation, and one of our principles is the right to life, regardless of what you say about 3 million people having problems and, oh, we've got to go to another country. So it's pretty simple. Right to life exists. What we do is we and it's in the 14th Amendment, right to life. And then you can stop all this garbage about abortions. Abortions are not allowed in the United States. If you want an abortion, go somewhere else.
Jeff, please unmute first, please, Jeff. Thank you, Nick.
Well, I'd like to address the equality argument because Bill proposed an interesting question. Should people's freedoms vary based on what state they're in? We have 50 states for a reason. If they have a constitutional right that is written into the Constitution, right to free speech, it ought to be the same everywhere. Freedom of the press ought to be the same everywhere. There's not a similar right in the Constitution regarding abortion. Therefore, the 50 states get to make their own decisions, just as they would for their own criminal laws and various other areas. And yes, your freedoms will vary depending on what state you're in. Otherwise, why even have different states? That is a fundamental reason. I also want to suggest that, yes, I agree. Well, I believe what Bill implied, that Roe versus Wade isn't going to die all in one fell swoop. I could be wrong. I hope I am wrong. My belief is that it will die like Lochner versus New York did, which was another substantive due process case decided on the same intellectual foundation as Roe versus Wade, which took away a bunch of wage and hour laws and things like that for workers. And it died a death of 1,000 cuts. The Supreme Court allowed exception after exception until the exceptions finally swallowed the rule. I think that is the ultimate fate of Roe versus Wade. And I think legislatures are going to be more and more active in testing it. And ultimately, that's what you're going to see. The democratic process will win in the end. And that's what I believe is going to happen to Roe versus Wade.
Okay.
In conclusion, Ruth Bader Ginsburg said, Roe, I believe, would have been more acceptable as a judicial decision if it had not gone beyond a ruling on the extreme statute before the court. Heavy-handed judicial intervention was difficult to justify and appears to have provoked, not resolved conflict. And if you look at the abortion protests out in front of the Supreme Court, every time there's a case, I think her wisdom there has been borne out.
Adam, please. And then we're coming to you, Fernando. But Adam, please.
Guidry, you say that the abortion debate has been politicized. Well, that's because you have politicized it. People like you that have gone to the courts and asked them to invent rights that have no basis in the Constitution and that are anti-democratic. And as a result, you've given the court so much power that in Citizens United and McCutcheon versus FEC, they prevented Congress from implementing legislation that would have addressed corruption in the electoral process. You have decisions like Shelby County versus Holder. You're politicizing it. You're giving power to a select few at the expense of the many. That's undemocratic. I completely reject it, and it's antithetical to liberty and freedom.
Fernando, please. I'm on mute, Fernando, please. Okay.
I am unmuted. I do agree that what they're going to try to is regulate it to the point where it doesn't exist, and that will keep the courts involved, which is why I propose that there should be a federal statute laying it out. It's legal. That's it. And that becomes the floor. Adam's argument is complete and utter nonsense. This became politicized not by marching in front of the Supreme Court or any of that other stuff. It became politicized when the religious right came here and started protesting in front of Planned Parenthood and preventing people from going in and exercising their right. You know, Nick is in this camp that you're supposed to keep your legs closed and all this other nonsense. Men and the women that go around saying that you need to keep your legs closed are the women that open their legs the most. The men that go around saying you need to keep your legs closed, you know what? You should keep your penis in your pants because it takes two to tango. And if there was a law in this country that said that you had to get an abortion after you had to get a vasectomy, a permanent vasectomy, not a reversible one, a permanent vasectomy. After you had one kid, every man in this country would be up in arms and it'd be going ballistic. Furthermore, all this other stuff that Nick keeps saying about the right to life and that the baby has a right, the baby doesn't have any rights. Let's get that out of the conversation right now. It's complete and utter nonsense. The reason you have doctors and everything there is to protect the mother. And this country was also based on the principle of self-determination and the ability to do with yourself as you see fit. And that is why it needs to stay legal, whether the Christian Taliban and Nick and the rest like it or not.
Guidry, please.
So I think that abortion is a right. It's not a privilege. And I am sure that my opinion is that abortion is prescribed in Constitution and it has to be regulated. It's not an absolute right. And I do disagree with Nick when he says, well, you know, there is right to liberty, life, and also personal happiness, pursuit of happiness. Nick, which right trumps the other right? All of these rights are at the same level. If the getting pregnant could actually take away one of the rights, which one to choose, your argument falls on those walls. Another thing I want to say that looking to what is going to happen, what could happen in the future in regards to the abortion, looking at the FDI's decision, it's a little bit worrisome because there is no appetite to really address and face the issue, and we'll see what's going to happen. And finally, I want to conclude my statement that always talking about this right makes me angry. It makes me angry as an independent, strong, educated woman. I'm not going to listen to Nick, Bill, Fernando, Adam, or Jeff, who's going to tell me what to do with my body and how to live my life. And I think there are certain regulations. You have to be humane. Nobody is going to kill a fetus when it becomes baby. But come on. We need to understand that independent women should have certain rights, and the right to privacy is included in the Constitution, and the right to abortion is part of that.
Okay, so Nick, I'm just no. I'm just going to ask you to land this plane, young man. Can we just land this plane? But I would like to let me offer this before you land us all safely. This has been lived up to what we promised. It's been a candid, open discussion. There have been some laughter, some poignant points made, but it reflects the divisions in America and in the law and what we are facing. And that's kind of what we want to do and strive to do here at the Lawyer's Den. We're not monolithic, and the world is not monolithic. But these points are important, rights are important, and our views are important, provided we do it in a way that is meaningful and informative. So with that, my erstwhile friend from North Carolina, can you land this plane, please?
Yeah, the right to life is mentioned in the Constitution. Abortion is not mentioned, but that's only for people who happen to read it. Abortion isn't mentioned at all. Life is. And with that, we'd like to thank everybody for watching The Lawyer's Den. I'm sure we're going to be back again sometime with a revisit of Roe versus Wade. Thank you. And Guidry goes, let's go look at something that took place 40 years ago. Who cares? Okay, that's political.